Next on our list of topics is the privacy standard set up by HIPAA. There are 18 identifiers that qualify information as protected health information. These identifiers could be related to past, present, or future conditions of an individual. HIPAA privacy rules apply for information that is considered to be PHI. The HIPAA de-identification standard states that all 18 identifiers must be properly removed if information is to no longer be considered PHI. Once all identifiers have been removed, HIPAA privacy rules no longer apply to the information.
In general, HIPAA states that PHI should be shared only with agencies and individuals who have a need for the information, and that only the minimal degree of information required should be released. Do keep in mind that where disclosures are required by Arizona state statutes, the privacy rules minimum necessary standard does not apply, because the law requiring the disclosure will establish the limits on what should be disclosed.
In order to keep patient information as private as possible, each covered entity should have specific members who process PHI. All use of PHI should be cleared through the HIPAA privacy officer that was assigned by the covered entity. When a covered entity receives a request for PHI, the identity of whom is requesting the information should be verified before sending the PHI. Disclosing PHI requires patient authorization before the information can be released.
Though there are certain circumstances where patient authorization is not required to disclose PHI, consult with your HIPAA privacy officer when requested for PHI to ensure compliance with the HIPAA privacy standards and ASU policy. A type of disclosure that requires a patient's authorization is the sale of PHI, which is defined under HIPAA as the direct or indirect financial or non-financial remuneration in exchange for PHI.
You must have a patient's authorization to sell their PHI, which must state that the covered entity will receive remuneration during the transaction. Correct. Public health and research purposes are not considered the sale of PHI. Covered entities must comply with HIPAA privacy standards for a patient's PHI 50 years following their death. A covered entity may disclose the descendant's PHI to others who are involved in that person's care, such as a burial home. After 50 years, the information is no longer considered PHI and should be disposed of properly.
When patient authorization is required, the authorization must be written in plain language and be signed by the patient. Authorization must include the type of PHI disclosed, purpose of the PHI disclosure, the date authorization expires, a statement regarding ability or inability to make treatment, payment, enrollment, or eligibility as a condition of patient authorization, the patient's right to revoke authorization, the name of the person or group receiving the patient's PHI, and a notice of potential redisclosure of PHI.